I'm sorry, we will wait for 5 more minutes just for colleagues to come back because they needed to do checkout. Yes. No worries. Okay.
Okay, I suggest that we now start very carefully, and I welcome you all again to this session, which is the last session where we are going to discuss issues. We are somehow now building a bridge from the session that we already had this morning, discussing experiences, lessons learned so far. But we are now trying to compile these observations and views and experiences into also looking into the future. Where are we heading and how to perform as judges and as courts. The title of this panel discussion is Lessons Learned, Future-Proofing the Judiciary and Ensuring a Convention-Compliant Response to Times of Emergency. This, of course, connects directly to what has been the red thread throughout our discussions. And as we have been highlighting in all interventions virtually, has been that although we are somehow relating our discussions now more or less directly to the COVID situation and crisis, we realize, all of us, that we are facing a number of emergencies, crises, on a number of levels, you might say. You have a sanitary crisis with the pandemic. We have a climate crisis with a long-term perspective, which, of course, will challenge humanity, but also courts. Our court in Strasbourg and domestic courts already have been faced with how to cope with this situation. We have, of course, the challenge, emergency of an ongoing war in Europe. We have difficulties when it comes to energy, food, migration, whatever, and I'm not trying now to make this day becoming very dark, but we have to be honest that we are facing very challenging times ahead of us. Indeed, this poses humanity and our societies with what can be described as an existential question, existential crisis. But I think also we have to be more constructive to say this is also now an opportunity for us as judges and courts to ask ourselves more existential questions as to what is our role in a situation that poses very huge questions to us as professionals, as human beings, and also to our institutions, be that domestic courts, ombudsman's institutions, NGOs, or international courts. We all have a role in this, and we have an opportunity now today to reflect and exchange on these issues collectively. And I think, of course, we can phrase the issues before us in so many ways, and it will probably be done also in the interventions we are about to hear. But I think we can at least single out two main issues that we need to reflect upon. First of all, indeed, how do we perform our job? Maintaining the rule of law, maintaining the protection of human rights, democracy in times of crisis. And that would be, the more acute question that we have to address and that we have already addressed in so many fashions already during our discussions. Secondly, which is connect somehow our discussion today with the opening speech of Robert Sparno. What would be then the task, what would be the role of courts, what is the role of democracy, human rights, and the rule of law in creating a stable environment, avoiding crisis, and also limiting the damage caused by emergencies and crises? Do the courts have a role, and if so, in what way can we make a contribution also in this sense? These are indeed very large questions, and they might possibly not be addressed as, more in the abstract. We need to be concrete, but I think it would be useful for us to keep in mind this. And it also, at least now on a more personal note, I find it extremely inspiring to be aware of the fact that although we are always, as judges, dealing only with one case at a time, we solve the case and that's it. That's the beauty of being a judge, you might say. But we are operating also in a broader context, and everything we do, everything we decide, plays a role in this larger picture. And sometimes we are able to stop up and to reflect. And we have now, today, the last session, a golden opportunity to do that level of reflection openly in this forum. And I sincerely encourage you all to take this occasion to share with us your reflections and experiences. Of course, there might be issues that you wanted to forward already yesterday or earlier today that you didn't have the time to express. Please feel free to do so. We have time today, and this is, in my view, a golden opportunity to have an open reflection upon what we are doing as judges and as courts in a very serious moment of time in history of mankind. And with these words, then, we have two wonderful speakers today. Two good friends, I must say, and I think I will only now give the floor to you, lady, to start with your intervention. Please, you have the floor.
Greetings. I will speak in Albanian, as the unwritten rule of our forum is, right from the beginning. According to the program, I was assigned to speak about the vaccination policies and the response to COVID in the region. I will mainly deal with the vaccination policies from the point of view of the European Convention and European law on a broader scale. And then I will invite you to share our experiences from the countries of the region regarding the vaccination policies. From the point of view of the convention right, the vaccination policy can be seen in three aspects. First, based on the obligation of the states pursuant to the convention to provide effective vaccination to all against the virus as an effective remedy to protect their and guarantee their health. Second, in the case of the approval of a vaccination policy, interventions can be made pursuant to the rights of the Articles 8 and 9. And then it's the quality of the vaccination, the quality of the medical treatment offered. First, access to vaccination or possibility of vaccination. In the case of a sudden outbreak and rapid spread of a new pandemic, as the case was COVID-19, the health institutions at the national and international level may not be ready, for objective reasons, to conceive and produce a considerable amount of vaccines that would limit or stop the spread of the virus. This was the case with the vaccines against COVID-19. The pandemic started in February-March 2020, and the vaccines for it were invented sometime in November 2020, so nothing was foreseen. Of course, we have to take into account effectiveness and safety, about which I will speak later. In these conditions, it is clear that it may not be possible for the authorities to provide a vaccine against a virus simultaneously at the same time, especially at the beginning of the outbreak. Another phenomenon is that vaccines cannot be available at the same time in the same quantities in different countries of Europe or in various regions of the same country. Therefore, the issue of the right of the individuals to have access to vaccines can be raised. There are two issues to this. First, do governments have a positive obligation according to Articles 2 and 8 of the Convention to provide vaccination to their citizens? It is interesting to stress that some contracting states parties, as the case was in the case against the Czech Republic, have referred to this positive obligation to approve vaccination policies. So it is, in the context of the convention, a positive obligation by the states to provide vaccination. If there is a positive answer to this question by the member countries and the case admitted it, there is a second question: how do the authorities meet their obligation to provide vaccination against a virus like COVID-19? There may be various parameters at play for such an analysis, beginning from the legislative framework, regulatory framework, to the operational duty to make accessible and effective vaccination policy. There is the acute issue of false vaccines that needs to be discussed. I will speak about that later. And the legislative and regulatory measures to avoid such practices. It is objectively impossible to provide a vaccine to all at the same time, the most so when the people want to choose the vaccination. Many governments have responded by drafting vaccination of policies to provide priority vaccination to certain ages and vulnerable groups. Would that be a policy in conformity with the convention? Such policies raise questions about the objective criteria to define priorities, transparency of politics, and non-discrimination. I will refer to an article published by Marko Milanovic, a professor at Nottingham. It's a very interesting article. It raises several questions. I selected some based on the broader concept of emergencies. What does the professor say? First, is Russia obliged, legally and morally, to vaccinate the population of Donbass, the eastern Ukraine region? First. Second, is Ukraine obliged, legally or morally obliged, to vaccinate the Donbass population? This is a case that might be submitted to the court. The first issue is jurisdiction, which is the greatest concern of Markovic. Then, if I come to the region, again referring to Marko Milanovic, if, he says, Serbia sends a contingent of vaccines to Bosnia, can Serbia, without violating its legal or moral obligations, specify that vaccines should be used mainly in the Serb ethnic entity in Republika Srpska within Bosnia? Can it do that? Marko Milanovic asks. If Serbia sends vaccines to Kosovo, can it, without violating its legal and moral obligations, specify that only those individuals who have Serb passports or Turk you have access to vaccinations? Or can it be said that though only those individuals that identify themselves as ethnic Serbs can have access to vaccinations? And last, very interesting too, Marko Milanovic says, a doctor in Serbia administers vaccines. After a working day and after he has finished all meetings, there are only 2 vaccines left. At the end of the day, they will expire. So he has either to use them or to throw them, discard them. There are 4 persons waiting in his clinic. The first is a Serb citizen, 40 years of age, healthy. The second is a Serb citizen, 40 years of age, but of Albanian ethnicity. The third, Bosnian citizen, healthy, 40 years old, ethnic Serb. And the fourth is an American citizen of Croatian origin, 65 years old, suffers from a number of diseases, and is married to a Serb citizen. And he has a very, very tough Serbian mother-in-law. This is what he said. And he adds, the mother-in-law has already been vaccinated. The question asked is, what should the doctor decide regarding these 4 individuals waiting to be vaccinated when there are only 2? How is he going to decide? What are the priorities? Who has decided these priorities? If I would refer to a report by the EU Agency on Fundamental Rights of 2020 in June, this agency raises the same issues. If I gave it an Albanian connotation to the same debate, I would say, with what political party do you belong to for you to have the vaccine? Or to give other cases of corruption that you have to pay to have access to vaccines. So these are some of the issues that appear when we discuss the vaccination policies. Now, mandatory vaccination after the vaccination policy has already been in place. With the outbreak of pandemic, the efforts of many states and international organizations focused on the development and production of vaccines. Legislative, administrative measures and organizational measures were taken. However, even before these measures started to be implemented, the debate, which you all know about, broke out. Is vaccine mandatory or compulsory or not? Do everybody needs to have the vaccine? This was a debate that started in 2020 and is still ongoing. While the Strasbourg bodies had the possibility to make it clear that voluntary vaccination does not constitute an intervention in the private life, the question remains, what about the compulsory vaccination? In the case of a positive reply, the duty to provide immunity to virus has priority over the right to choose whether you want to be vaccinated or not. Yesterday, we referred a lot to this, and the Grand Chamber of the European Court in 2020 started the proceedings, online proceedings, in the case against the Czech Republic. Even though this case was not related to COVID per se, the COVID situation, I'm speculating now, was in the minds of the judges when they made the decision, Vabrička. Even though in its ruling the court tries to distance itself from the COVID situation because it was related to hepatitis, poliomyelitis, and the compulsory vaccination of children, an early policy in the member states, in the court decision it was said that there are some very important principles that can be used in every policy for compulsory vaccination. The number of third-party states that intervene shows the importance of such an issue that is vaccination issue. First, I'm trying to avoid some paragraphs that was mentioned yesterday by colleagues who spoke in the last session. That is being foreseen by the law and proportionality and so on. I would like to recall two aspects. First, the court confirms its previous judicial practice considering that compulsory vaccination as a medical involuntary intervention constitutes an intervention in the right to respect of private life pursuant to Article 8. This would confirm the proposal that compulsory vaccination constitutes, in fact, intervention in the private life. Then later, the court deems that the duty of vaccination may be considered as linked to the effective enjoyment by the individual of the intimate rights and raises sensitive moral and ethical issues. When we speak about the justification of the intervention, the Grand Chamber in Varvachka and others continues with the traditional test. Initially, whether the intervention was foreseen in the law. Colleague Ilievsky said it yesterday. The court answers this question recalling the criteria laid down in its case law, which legal provisions that provide for vaccination should be accessible in an adequate manner and formulated with sufficient accuracy to make it possible to those that apply it to regulate their conduct, and if it's necessary, to provide the necessary advice. This is very important also for the authorities when they approve legal acts and bylaws regarding compulsory vaccination against COVID or other diseases. It's very important, and this links it to the first aspect. Then in Varvachka, the Grand Chamber examines the legitimate purpose or aim in the implementation of such policies. The court is clear, saying that such measures follow a legitimate objective, protection of health. That is the positive obligation of the states to help the health of people's health. The test of justification was referred to yesterday. Without wanting to repeat it, I want to say that the court recalls that the member states have a wide margin of appreciation, bearing in mind the legitimate objective, that is, protection of health. An element in the appreciation of this is the element of social urgency, which is very important in emergency situation. I'd like to underline another aspect. In Varvachka, the court underlines that the opinion of experts in the perception of such policies should be decisive in drawing the conclusion whether the concrete social needs require it. So the specific weight of the experts in deciding whether they have referred to all this, the court refers to the expert's opinion, and in the case against Czechia, the best interest of the child. From what I have seen, and you can discuss later also regarding this, the policies of the region has taken into account such priorities, the age, vulnerable groups, and so on. Another aspect that the court underlines in Varvachka, and that may be very important in the context of such policies in the countries of the region too, is that of transparency and public debate when such policies are mandatory vaccination policies are adopted. What is important, and it was mentioned by the Ombudsman for Albania, is the existence of institutional safeguards in the control of legality, proportionality, when approving such policies. And we can add to it the European consensus in such situations. They provide a very useful guide to all the authorities of the member countries regarding the stand to be taken in the cases of compulsory vaccination. Third element, which is closely linked to vaccination policies, the quality and safety of vaccines. In all the countries of the Western Balkans, vaccines have been administered from all companies and authorized by foreign authorities. In the cases of EU EMA The Hague or their counterparts in the United States, Russia, China, and so on. The question arises whether such vaccines should be subject to a preliminary authorization by the competent authorities of each country before such vaccines can be administered to the local population. That is, who is responsible to authorize a certain vaccine. I recall the way that the Strasbourg court gives to the experts. So if an Albanian takes up Pfizer vaccines, or Chinese one for that matter, and suffers a very serious reaction which leads to loss of life, can there be a complaint lodged with Strasbourg after the domestic remedies have been exhausted on the claim that the vaccine, one or the other, Pfizer or Chinese, were not authorized for use by the Albanian competent authorities? We have to recall that in the case Battaglini against Russia, the court went so far that it identified violation of Article 3 of the Convention for the administration of medicinal product not authorized by Russian authorities. So this is a question that is of interest. Allow me to deviate a little bit here and refer to the EU court because they have a very detailed case law regarding the safety of medical products. In the decision, remember, Pfizer and Alpharma in 2002, before we recognized Pfizer like we do today, the first instance tribunal in the EU, a response to the European Commission regarding safety of vaccines produced at the time by Pfizer for other epidemics. It says, tribunal, the risk assessment is made on the basis of a scientific process aiming to identify a danger, characterize it, and assess the exposure to that risk. I stress that in the decision against the Czech Republic, the role of a certain scientific policy was as a very important element. In another case, when France was implementing vaccination policy in 2008-2009, a case was submitted to the European Commission, and the EU court uses 3 steps to approve safety of a vaccine. First, identification of potentially negative implications of a proposed vaccine. Second, an overall risk assessment based on the most reliable scientific data and the most recent outcome of international research. And third, when such results are insufficient or inaccurate, but the risk still exists, the principle of care, which is a general principle, justifies the taking of measures that need to be objective and non-discriminatory. This is the policy that the EU tribunal defines for the member countries. My question is, what is the standard for the non-member countries? Leave aside Croatia, for the other countries of the Western Balkans. The EU tribunal underlines that this is an analysis that needs to be conducted by the authorities of every country. Of course, this aspect is very closely linked with the consent of everyone to agree to vaccination. It is linked to the policy of compulsory vaccination. You need to know what kind of vaccine is being administered to you before you can consent. And this is very important pursuant to Article 8 and some other article of the Convention. It would be of interest that during our debate we exchange opinions whether such a process of approval of the quality of vaccines administered in our countries, coming from EU, Turkey, China, whether that is done by the authorities of the countries of the region, and based on what criteria, if yes, was such analysis or administration of vaccines. Thank you for your attention, and I look forward to any question you might have or debate.
Sorry. What I said, we wait with the questions until we had both interventions. And I thank you so much for your intervention. It was extremely thought-provoking, I might say. And also, I think you connected, as I said initially, we work concretely. We have to start with something concrete. But what you described was, of course, also the framework of our court, that is the European Court of Human Rights, how that court has approached in the Wawrinka case to define its role not only in the context of that particular case, but also more generally, the approach taken vis-à-vis vaccination in general. But notably, I think what you explained very clearly, the need to have as the starting point here, the duty to protect life and health on one side, and then on the other side, the duty not to overstep the limits, the need to find the right balance. This is, of course, the starting point under the convention law. But then, what is the court's role and what would be the role of others? And of course, it's very clear from what you explain now, the court has a very clear approach based on long-standing case law. It's not the court's task to take over in managing a crisis at all. But there is a need to have a certain level of control. You emphasized that it would be primarily for the domestic authorities to make this assessment on the basis of scientific knowledge, and the court would be very open to that. So we will be ending up with, how to say, to trying to explain that the role of an international court, notably, would be to see to it that there is actually an assessment, there is a balancing, and also that this balancing, when it comes to interference with other rights, that it has a legal base and that it also then carried out with the necessary safeguards against arbitrary use of public power. So based on what the exact case that you mentioned, I think we can already derive something as what would be in the broader picture would be the proper role of an international court, at least. Now we are turning to a different issue in some sense, but it relates very closely to our overall discussion. So Miana, you have the floor, please.
Speaker, and I will try to refer to previous discussions and somehow to sum up what was what was learned from the crisis behind us, maybe behind us, but also with the crisis that we are facing now in future. That what I can say is that we've learned that the COVID-19 pandemic took states by surprise and demanded a quick response from authorities without the major knowledge of or experiences to understand how best to prevent the spread of the virus. But let me remind you that the convention drafters were aware of the need for tools for containing outbreaks of infectious diseases, and such mechanisms were built into the text of the Convention. Article 5, paragraph 1e, permitting the lawful detention of persons for the prevention of the spreading of infectious diseases, and Article 2 and 3 of Protocol number 14, permitting restrictions to be placed on the exercise of free movement rights for the protection of health, provide two relevant examples of this. And as we can see in past, these two articles were used, of course, not in such a, let's say, demanding way as it was this time, but to these two or three articles, let's say, the applicants were referring. In emergency situations, such as the COVID-19 pandemics, states were required to act quickly to make sure that the health to the citizens, their safety and their lives are well protected, and to take measures to contain the spread of virus and to protect the life and health of their citizens, but also citizens of other countries which were entering or exiting their states. On the other hand, the measures taken to protect health impacted the enjoyment of numerous other rights and freedoms. And this is what we see now in front of the European Court of Human Rights. That's why the applicants are referring on different angles of the human rights and from different perspectives. The diverse measures taken to protect health and to ensure the continuing functioning of legislative and judicial bodies mean there are many aspects of the pandemic from which to gain valuable lessons learned. Additionally, the court's case law relating to general principles of wider application beyond the pandemic, and we can say that in past 2.5 years, we were able to learn that when states are required to respond quickly to a serious and complex emergency, parliamentary scrutiny of the emergency measures and their compatibility with human rights might not always be possible. And this was the case in my country. In Macedonia, parliament was unfunctional. So, effective and independent judicial scrutiny of emergency measures becomes even more essential to hold governments to account and protect fundamental rights. All exceptional measures which are taken to protect the life and health of a nation must still comply with the Convention principles of lawfulness and proportionality. Courts, as well ombudspersons, NGOs, press, social media, as it was rightly pointed by my colleague Judge Bartsen yesterday, have a vital role to play to monitor compliance with these principles. They must seek to ensure that human rights remain a central consideration to any emergency response, that emergency measures serve the purpose to which they were introduced, and that they do not interfere with the convention rights beyond the extent that is necessary in the context of the emergency. We learned from our own experiences, but also from other countries, that following the adoption of national emergency legislation, some states also choose to derogate from convention on the basis of Article 15. This is not a new approach. We have seen this in the case law of the court, starting with the case of Lawless versus Ireland versus UK, then Akçoy versus Turkey, Cyprus versus Turkey. The court was dealing with situations that states were derogating and referring to Article 15 of the Convention. But what is new is that this was the first time in Convention history during which states reached to the same, they reacted to the same emergency and to very similar problems in different ways. Some states were using derogation as a tool somehow to protect what might come in front of the court. Others were not reaching on Article 15. Even where states did not declare a state of emergency, the COVID-19 pandemic prompted many of them to adopt new legislation and administrative measures, and in many cases, states granted exceptional powers to the executive to design and implement measures ordinary outside their area of competencies. In many of our states, executive powers overtook the role of the legislator. Exceptionally, the operation of the democratically elected institutions and the judiciary was either interrupted or limited for a few weeks, and in some cases for some months. This was particularly evident in countries of Western Balkans, including my country. concerns were raised as to whether this situation could endanger the rule of law and democracy. And yesterday, President Spano spoke about the danger for liberal democracies in a situation of crisis, as we have seen, pandemic of COVID-19, but today we are facing different crises, like energy crisis, economical crisis, and this is why lessons learned from this, let's say, critical situation might be useful for whatever will come in front of our national courts. Across states, different approaches were taken to ensure the continued functioning of the legislature and judiciary, adopting different procedures for review of the measures introduced to respond to the pandemic. It is, however, important to emphasize that under the Convention, their actions must always be in conformity with the text, principles, and spirit of the Convention. We learned from Judges Aike, from Judges Pavli and Ilievsky, that several judgments and decisions relating to the COVID-19 pandemic have now been decided by the court in Strasbourg. However, numerous applications concerning the COVID-19 pandemic remain pending before the court and other courts, and the jurisprudence delivered so far does not cover the entirety of wide-ranging issues which were raised in front of the court. We also have now Swiss case in front of the Grand Chamber, which will be extremely important, not only for the cases linked with pandemia, but also with the case law of the court on Article 11. The court acknowledged that the pandemic gave rise to complex questions concerning competing rights and that states were required to take exceptional measures to respond to the pandemic. Certainly, the court affords states a wide margin of appreciation in matters of emergency and the development of health and economical policies. And this is what my learned colleague Bianco was covering. Despite the challenges posed by the pandemic, states remain under an obligation to make a careful assessment of their interference with the rights and freedoms of those within their jurisdiction and to limit their impact on these rights only to the extent and for only so long as it was required by the emergency. States might have needed to be creative in their approach to enable courts, legislators, and other institutions to continue to function during the pandemic. Such lessons learned will be relevant for future proofing that judiciary and legislative scrutiny in the context of other emergency situations will be extremely important. We learned that the protection of human rights should not be viewed as an obstruction to the protection of health. Barvitska versus Czech Republic is elaborating to these aspects of balancing between right on health, which is part of the right of privacy covered by Article 8, but also we can say that on the contrary, the protection of rights required the protection of health, and this was clearly visible during the pandemic. Application of the principles of legality and proportionality can only help to ensure measures taken to respond to the pandemic, and they will be effective in their goal of protecting health without infringing other human rights to an unnecessary extent. The provisions of the Convention and the case law of the Court provided helpful guidance regarding the interest to be taken into account when responding to a crisis situation. We, judges from the national courts, we were looking above the case law of the court in Strasbourg, but also we were searching for tools which will be more let's say, acceptable to the circumstances in our countries. We learned that there must be mechanisms for review emergency measures and to ensure that the proposed measures are in reality being applied and enforced, and that there must be scope for some other form of parliamentary, judicial, or expert view. Review by an independent and effective judicial body of quality of law introduced during the time of emergency and the application of such laws in practice is the other key way to prevent the abuse of rights during an emergency situation. In this type of lessons learned, we've seen that the constitutional courts were extremely important. They were able to react quickly and to address the problematic directives or decisions from a side of the executive power, and we have seen this in the decisions of the Constitutional Court of Bosnia and Herzegovina, Constitutional Court of Kosovo. Croatia was also mentioned by the Ombudsman in the work of the Constitutional Court of Croatia, and I will mention here also Macedonian Constitutional Court, which was burdened with more than 100 applications at the time of pandemic. We learned that the decisions such as inadmissibility decision of Saakashvili versus Georgia are sending messages to the states that they should ensure that the courts remain open during the pandemic to the extent possible to help individuals to challenge alleged infringements of their rights. For example, courts should make innovative use of technology to hold remote hearings where necessary and appropriate, or implement safety measures to protect those who are able to travel to court in person to ensure that alleged serious violations of rights continue to be heard. Serbian Supreme Court of Cassation was using online hearings, and this might be also a good practice that we can further probably analyze and try to implement. At the same time, we have experiences of other courts, including my court, where the cases linked with the detention were held with physical presence, even during the pandemic. To challenge any COVID-19 restrictions before the COVID, it remained necessary during the pandemic to first, with order to first exhaust domestic remedies. And that's why the principle of subsidiarity and the role of national courts was extremely important, because in this way, sometimes the courts could react on time, and they could prevent also the huge number of cases in front of the European Court of Human Rights. But we learned from our colleagues from Montenegro that other methods also might be used, as it was done by the state agent, who on the basis of friendly settlement managed to solve 3,000 cases, which, if they were not solved on the basis of friendly settlement, will now wait in front of the European Court of Human Rights. But all this requires the continuing cooperation of domestic courts, not only during the pandemic, but also after the pandemic situation. So courts are now obliged, because if the pandemic situation is behind us, are obliged to analyze what they have done, what could be done, and how we can proceed in future. I think it's not enough to wait for the international organizations to develop guidelines, or it's not enough to wait for someone outside of our institutions to bring us what is the best methodology and what will be the best practice. We can also work on our, let's say, on the basis of our own experience. Another way in which states could seek to ensure accountability during the pandemic was through the appointment of experts within government or external expert bodies to oversee and advise on executive action. We have seen this in our countries. We have seen that the ministries of health, the prime ministers were advised by different experts. They were in constant communication with the World Health Organization and etc. And in this type of crisis, these forms of dialogue is extremely important. Also, an existing independent ombudsman was not only important, but the presence of ombudsman was of crucial importance in some cases during the pandemic, because the ombudsman could provide not only help to the vulnerable groups of citizens, as it was already pointed by colleagues from Montenegro and Albania, but also they were able to reach to the governments or to the executive part before the case will come in front of the courts. We can conclude that now we know more how to react during the pandemic crisis. And we can conclude that we, judges, ombudspersons, people from non-governmental organizations, or better to say, the human rights defenders, we are extremely important during the crisis, because without us, those who will be facing a possible breach of their fundamental rights will be desperate. And we have seen this during the crisis. And I will end up my intervention by referring to the opening remarks of the president, of the former president, Robert Spano. Liberal democracies require respect of human rights, and we will have to protect not only human rights, but also in this way, liberal democracies. Some of the participants from non-governmental organizations were mentioning the fear of autocratic approach in some of the states, and we will agree that there are no other ways except protection of human rights, development of better standards, and of course, our eyes will be open for whatever comes from the court in Strasbourg, and on the other side, the court in Strasbourg can count on us from national institutions, from courts, from non-governmental organizations, and we will be, in a way, your, let's say, safeguarding instruments at the national level. Thank you so much.
Thank you indeed, Mirjana, for your sharp analysis and your wise and forward-looking approach and advice also. You provided us with a panorama of perspectives, and you also highlighted the role of all stakeholders involved, not only the international courts, domestic courts, but also the Ombudsman and NGOs in particular. I also noticed that you emphasized now to the very end of your intervention the importance of dialogue between the international environment and the national environment, of course also inside in the domestic context. And that brings us, of course, to where we are now, the dialogue element, which is now, of course, now I invite everyone that would want to make a contribution to this exchange of views, not necessarily directly connected to what has been addressed by the interventions, but also more generally within the framework of what we are trying to do as judges, ombudsmen, members of NGOs, whatever, in order to facilitate the protection of the rule of law, democracy, and human rights. So please, the floor is open. I apologize not for being able to see your names, but if you show a sign with your hand, then I will give you the floor, please. if no one is prepared to take the floor immediately, then I will do, and I might share with you some of the experience that we did at our court, the court in Strasbourg, dealing with the situation and the impact it had on the court as such. As any court, we were of course struck with the situation immediately, with the close down 2020 spring, March. We are not a court hearing evidence. We are not a court that would normally have to have oral hearings. We do that only when we have a grand chamber case. That's not very often, 15 times every year or so. So in that sense, we are not that vulnerable compared to domestic courts, and notably trial courts that need to hear witnesses and to operate fully with having hearings on a different scale than we normally would have. We always only hear the lawyers, and that's it. So we were luckily able to very rapidly to transform the operation of the court into being an online operation with lawyers participating online, although the judges had to stay in the courtroom. We had then the lawyers presenting on a large screen like this one, and the judges would then be present in the hearing room. I remember very vividly, and now it appears to be a long time ago and perhaps a very strange discussion, but one of the first discussions we had among the judges when we were about to have the first hearing online with the judges being there in the room, are we actually obliged to wear a mask as judges? And is that even possible for a judge to wear a mask in a hearing? Are we not supposed to? Are not the parties entitled to know the faces of the judges? A faceless justice, is that even possible? Of course, after some time, and well, not too much of a time either, we realized that we didn't have an option. It was either we have a mask or we won't have a hearing. But that was really, it shows that we had a reflex initially that said there is something very tricky going on here with having an online hearing with a mask. It also somehow demonstrated to me that we are extremely adaptive, not only as judges, but as human beings. We get used to so many strange things. Nowadays, a mask is really nothing. And the idea of a judge having a mask is just the daily business. But that I remember very vividly was the first difficulties. We managed that. We managed also quite rapidly to enter into what was a new mode of work, online work. You all know this. We had all our deliberations among the judges, most of the time online. We somehow figured out how to do that. Personally, I have to admit, I found it difficult. I still find it difficult to have a good conversation in a difficult case with a colleague online. You have also, of course, some security issues there. I'm not sure whether we were fully in compliance with what would be the best recommendations as to not being too accessible for the outside world. At least some of the cases we dealt with were, of course, sensitive, and we just had to find a good compromise there. And I think this is, speaking of lessons learned, I think what we learned, we had to be adaptive, we had to respond in a creative, pragmatic way to a number of challenges. For example, the issue of, and this is in principle very technical, but still extremely important, the issue of the 6-month rule under the convention. As you might know, there is the 6-month rule. Now it's actually 4 months, but it was at the time 6 months. And we realized that a number of potential applicants faced a serious problem. They did not have access to their file. They did not have access to a lawyer. They didn't basically have access to anything. We were in a lockdown. And then they could not communicate freely with us. And how do we then proceed with the 6-month time limit? Of course, we could have carried on just as business as usual. 6 months, you're late, too bad. But of course, that is not an option. That is not a way to deal with the crisis, to say we just continue as if nothing happened. The first step there was that the president of the court decided that we will now add 3 months to the time limit in order to facilitate the necessary time to people to adjust to this. That was the decision. It appeared to be at the time to be the only viable route to take. But at the time, there were no legal basis for the president doing that. Definitely not. But he did. And he did that in the hope that eventually the court would agree that this was a viable route. And then the first case where this then came on the table before the court was the case we already addressed the court case. It's a case called Saakashvili against Georgia, where the chamber was faced exactly with this question, whether we should somehow approve or not approve the approach taken by the president. And well, no surprise, but the section accepted this, emphasizing a number of elements, but notably that this was actually necessary to do in order to secure the respect for the right to application to the court. This was the only way to safeguard that principle, which of course access to court, in this case international court, but similarly for domestic courts, is crucial also in the time of crisis, and that this was the only viable route in order to safeguard that. And this of course was a very, you might say we solved a technical issue, but I think it tells us that we have to be adaptive, pragmatic, and we have to realize that sometimes as judges we face questions and challenges that we have to find new answers. In the case law of the Strasbourg, of course, we always say that the convention is a living instrument and it needs to provide us with the answers we need to deal with the present day situation. Normally this will be then in the context of the substantive provisions, but in this case, notably, we can see this playing out also when it comes to the application and interpretation of the conditions on admissibility. I would want to now to turn to my colleague Tim, if you allow me, Tim, to fill in a bit on a different part of the experience we had at the court when it comes to interim measures under Rule 39 of Rules of Court, because you have ample experience with that and you cope with this also in the days that we were facing this crisis. So could I please ask you just to fill in a bit on this?
Thank you, Arnfinn. Yes, I'm currently and have been for the last 2 years one of the 3 duty judges at the court responsible for interim measures and Rule 39 indications. And of course that's where we met, well, where we had the first encounter with COVID and the first interface judicially. Do we intervene in cases? It has to be said that the large number, I think something in the region of 380 applications arose in the context of detention measures where people applied to the court for an order that they be released from detention because detention enhanced their risk of exposure to COVID. Now the test for an interim measure under our case law is one that is in principle very strict and requires there to be an imminent risk of irremediable harm in order for the court to indicate to the respondent government that specific measures should be taken, measures which, if directed, are binding as a matter of international law. And ultimately, if I remember rightly, none of the applications in relation to detention were in fact successful, certainly not on the COVID ground alone, so there was no order for them to be released as a result of the COVID ground alone. We also had a number of cases in relation to extradition, and some of those were granted, but again, probably not on the COVID grounds. This was frequently extradition to the United States, where, of course, the outbreak at times the news of the outbreak was very virulent, and where the risk was that a person would be extradited from a member state to the US to be then held in a prison where the incidence of COVID was extremely high, and where applicants had certain vulnerabilities that was certainly taken into account. But again, I think the reality from our point of view, and it in a sense reflects most of the engagement of the court with COVID so far, is that if they were successful, they were usually successful on other grounds, one of the grounds being that with the US, if there's a risk of life imprisonment without parole, until very recently, our case law was awaiting clarification in the Grand Chamber, which has now happened, and therefore that usually was the basis for a grant. So ultimately, I don't recall there to have been many, if any, COVID-related Rule 39 incidents or applications that were successful. But it is, as I said, it's the first and the most immediate engagement the court has, usually in the form of a duty judge, with these incidents when they arrive. So that's perhaps as much as I can say on Rule 39. But while I have the microphone, can I perhaps just point out one other issue, and we can come back to Rule 39 if there are questions. I can see fingers twitching by microphones. But I just wanted to make one other point, and that's about judicial dialogue. And I made the point, and Darian Pavli and others have made it too, how the limited engagement of the court with COVID specifically so far. But I think in the dialogue, I just want to draw attention again to the tools which the court is trying to make available and accessible to both the courts, which are part of the Superior Courts network, where of course there's a huge array of databases, including transversal themes relating to COVID, which can at least help inform the work and certainly informs our work. And there is now, and that's perhaps of interest for our NGO representatives and to some extent the Ombudsperson, there is of course now the public-facing knowledge-sharing platform which the court has put on its website, on which there is, and I've asked the team to show you on the screen. So if you see, that's the front screen of the court. If you go to the top right-hand corner, the ECHR-KS there, if you click on that, then you get our knowledge-sharing platform. And if you scroll down, you effectively get behind each of those. So, for example, if you click on Article 8, you get a commentary of our case law on this article, updated every 3 months with the most up-to-date case law. Can you go back to page 8 for a moment? Page Article 8. If you scroll down, you also get references to the most recent decisions under these articles and a link to the legal judgment and the legal summary produced by the jurisconsult. So just in terms of accessing where the court is in relation to its case law, that I think is an extremely useful tool. Even if it doesn't provide an answer to COVID itself, it will, under the relevant articles, if there's a COVID-related decision, you will find it there where you now see A and others against Iceland, IM and others. And that is, as I said, the case law guides and the commentary, so to speak, the collection of our case law is updated every 3 months, and is currently, I think, up to date as of August this year. So I just wanted to highlight that exists. And as I said, those courts, which I think is most of the superior courts of the countries represented here, are now part of the Superior Court network, where that is available, plus quite a lot more, which should help with that work. So on that note, I will stop here.
Thank you very much. I have one hand down there. I think we started.
Okay, thank you.
Okay, yeah.
Biljana?
This is just to connect.
Okay.
Because I was discussing the platform with Anne Austin, and I know that now the court is looking towards governments to facilitate translations, and I think with Italy there is an arrangement there already. So I think it would be quite useful, because the language will be a barrier, for everyone here in the room as well to sort of filter that back to the governments, especially for those of us who speak similar languages. We could perhaps pull together with Croatia, and then of course, you know, I mean, in Macedonia, some of that can be used. For Albania, that'd be different, and Kosovo. But because it's really fantastic, the platform is, I think, none of us need to do anything else. I think we just need to translate it now.
Thank you very much, Tim.
Thank you.
Also for this. Please.
And the Bilton's Affairs Center are very valuable, and they will bring us...
We will carry on with those.
Yes.
For all time's sake.
I have to say that each judge in Serbia gets this bulletin, and it's, I don't know, I just love them. I have collection and I keep them. Okay. I just wanted to mention one issue that's for me as a judge and someone who is involved in also the issue of smuggling of people and the freedom of movement. It's like smuggling of people is the hardest issue for me, but I won't talk about that, you know, considering the right of free movement. But anyway, I think that we are facing also the problem of freedom of movement, considering that countries are conditioned our entry to some countries on the type of the vaccine that we got, you know. So I think that's something it's maybe it's very important to be considered in the future on some higher level or whatever, because all countries didn't have all the vaccines. They were not all reachable for all the citizens. And also in some countries, some vaccines like Russians and some other Western vaccines were kind of proven by our medical authorities. So it was our free choice which vaccine we shall get, you know. And then I noticed that somehow in choosing which vaccine, we were thinking, okay, where we can travel with this vaccine, although some vaccines were maybe better for some categories of the people, you know. So for me, it's kind of really discriminatory in a way, you know. And we didn't get the proper and timely answer on all types of the vaccines, whether they approved by World Health Organization or not. And I think it was kind of a way, it was a politicized issue, as usually sometimes we face that too. But anyway, that was how I felt that my freedom of movement was restricted. I mean, I got the Pfizer, so I could travel everywhere, but somehow, if someone told me, because there were some doctors telling you Pfizer is not good, you know, the other vaccine is better for you, whatever, but then it was the hard decision on the citizens considering the right to travel all over the world. And then I think, as my colleague from Constitutional Court of Albania said, that still we have to see the results of the work of the courts, because there are still pending cases, especially in the Supreme Court, in the Constitutional Courts. And I think that this is big importance of this conference also, that give us more perspective how to decide and what to consider. And also, I think that it's very important that I think I talked about that the first day when we review on appeal level and also in the Supreme Court on extraordinary legal requests that they can use in front of the Supreme Court of Serbia, that we somehow really reasonably rejected some verdicts, that some people were punished with some got the jail punishment or whatever for offenses against medical laws and not respecting the restriction of movement or whatever, considering facts. And so I think there is quite a lot of those decisions. So I think it's also a good practice and the good results of the work of the court that we somehow, you know, recover. It was kind of restorative justice from that point of view. So I think that we still have a lot to do and lots of temptations are in front of us to get ready for another emergency situation. Thank you.
Thank you so much for these perspectives. Please.
Thank you so much. I was provoked by my colleague Barton in his intervention. I would like to share with you now, not as a panelist, but also as one of you, as one of the participants, two experiences in my country. First of all, similarly like European Court of Human Rights, I will have to pay tribute to the government for one thing. At the moment when emergency situation appeared and when the president of state came with the decision for that the next period, there will be interventions from a side of the government, and they will come with special decrees concerning the crisis. The government came with a decree by which they prolonged the period for all appeals in criminal, civil, administrative proceedings for the period which, as long as the pandemic will last. And I think that this was used broadly in the region, and all states were, and this was, I would say, extremely useful and positive form of protection of rights to access to court for all our citizens. Second thing that I thought it will be interesting to share with you is our experience as judges in Macedonia. Unfortunately, we have one of the main problems in our system is the fact that we don't have independent judicial budget. We are completely dependent on the political will of the government, how much they will divide for judiciary. And despite the fact that we have in the law on budget 0.8% of the state budget prescribed to be immediately somehow reserved for the judiciary, each year we receive 0.32%, so it's not even half. And during the pandemic, the government came with the idea that they should cut automatically from the salaries of judges and all judicial clerks 20% from their monthly salary for next, let's say, I don't remember, was it 3 or 4 months? And it was so offensive. Executive part of the state was interrupting the financial independence of the judiciary, which is not even clearly independence. We are completely dependent on them, despite the fact that the whole judiciary is with low salaries. They were intervening with degree. And of course, the Association of Judges and Association of Clerks working in judiciary reacted immediately, and we've sent initiative in front of the Constitutional Court claiming that this decree is unconstitutional. And you cannot imagine how strong was the reaction of the journalists, which are mainly pro-governmental, and there were no other defensive voices because it was so strongly addressed towards the judges that they are not, they don't have sense for solidarity during the crisis and etc. But the association came with statement that we will collect money on the basis of solidarity, and we will send this money directly to this special budget which was created for fight of the COVID. And of course, we have done in this manner, and probably we were the only ones in the state that were donating money, even more than they were envisaging. For next 3 months, we were donating money from our salaries to this fund. The decree was, of course, unconstitutional. We legally we received the challenge, let's say softly. But then in the end, there was no public reaction on the fact that the judges were contributing on a solidary basis and with a lot of empathy towards the situation in crisis. And I guess there were similar experiences in other countries, but this is just to give you one little example where the judges were also in front of the courts challenging the legislation which was not in line with the Constitution. Thank you.
Thank you so much for also sharing that experience. We are now about to reach the end of this discussion too. Lady, I would give you the floor if you want to make any observations or summing up, please.
I very much thank our colleague from the Supreme Court of Serbia, for example, I didn't thought of that aspect of the type of vaccine and freedom of movement, which is indeed a very important aspect under freedom of movement in specific countries. And I thank you very much for this. I would have preferred to have a kind of feedback on the vaccination policy from the member states. I did the research from the moment that I was assigned to speak on this topic. Probably for linguistic problems, I wasn't able to find it, but certainly in Albania wasn't clear for me how the vaccination policy, for example, in Albania was adopted, why certain ages, how was conducted the consultation with specialists, with experts. There's basically no public consultation on the policies to explain why that policy, why that range of population, why not the other range of population. At least I wasn't able to find official documents, but I stand to be corrected by the participants. And it would have been interesting, even by writing, I mean, later in the coming days or weeks, to have a reaction on that in order to complete a little bit our picture. And when we conclude on the lessons learned, as we discussed with Biljana, that would be a kind of idea also on the operation of courts, vaccination policies. We might take these into account because they might be important as well from the perspective of the convention. So that would be my final word. Thank you.
Thank you very much. Then I think in closing now this session, I would thank both of you for your interventions and for the contributions by all of you. And allow me, I will not try to sum up. That will be, I mean, you will take care of the summing up more generally, Biljana, but I want to use just this occasion to thank you all for having me here. I enjoyed a lot, both the exchange that we had both these days, but also meeting you, and I can assure you that I had now already a far better view on the context in the region that I had before, and I hope that I will be able to meet many of you again on later occasions. And on that note, I hand then the floor to you, Biljana. Thank you so much.
For a while is that I should keep it brief. At this point, both Goran and I should be very brief. I mean, we had really interesting 2 days, and I think sort of had 2 parallel conversations. In effect, one was more about sort of this uncharted territory that COVID presented to everyone, including the courts. The cases that made it through the system, both domestically in Strasbourg, and some will only make it through the system. How did the courts react? How did the courts adapt? And we've heard from Arnfinn very usefully and from Tim about what measures Strasbourg court took to adapt to the crisis. Are we happy with how we adapted? How could we, in the future, react differently? And did the judiciary exercise the necessary scrutiny, in particular of the measures of the executive? And that's sort of one level of discussion. I think the other one, sort of very much in sync with it, was what former President Spano opened yesterday, which, to my understanding, was about whether liberal democracy can survive challenge of populism that thrives in crisis. That time and again thrives in crisis, so any crisis is an excuse for a challenge. And, you know, this model that served Western Europe so well for decades, you know, what are the fundamental values and principles and rights that you cannot afford to compromise on? Because if you do so, you erode the fundamentals and you erode the system that was underpinning your peace and prosperity and security. And for us in the Balkans, I think you ruin our only hope to live in decent societies. These are the societies we aspire to. and we look towards. And I think it is a bit disheartening to be watching, you know, something that could be unraveling of a system that we are hoping to become part of, so that all these sort of things that we started discussions about back on Thursday night, like keeping the youth in the region, like sort of people actually finally feeling that they're belonging to decent societies that are run by rule of law, where everyone is equal before the law, that are not ridden by corruption and organized crime, finally become societies of the Western Balkans. And then the role the judiciary plays in it, because we shouldn't be looking towards politicians. Their systems of incentives are different. It is all about what's the political gain and what is the lesser political loss, which is very different from protecting model of liberal democracy long term. And it is our task as sort of organizers to try and sum up in very unofficial review of our discussions the conclusions on both, and show the connection and show how important this response to COVID crisis is for the wider fundamentals of our societies. And then with your help, share that with policy and decision makers throughout the region. That is one thing we'll do. Another thing that we will do, and I'm looking to Sinisha, is we will look to offices of the Ombudsman throughout the region to put together a paper on your experiences and your lessons learned, and share that. And we are very open to discussing same or similar approach with constitutional and Supreme Courts, so we should look into that too. And then the third thing we'll do is we'll organize the 10th Regional Rule of Law Forum, and we need to raise the bar. I don't know quite how, but we'll think of that. Thank you very, very much. I mean, again, all our speakers who were absolutely fantastic, all of you. I've heard very good things about the event from you in the last day or so, and I hope you're not just being nice to us. I think I can work out when people are being genuine. I think you are genuinely finding the discussions useful. Huge thanks to team of Civil Rights Defenders and Air Center, to Dreamland, who have made the logistics possible, to interpreters, of course, to Vesna, who is tireless. We will have so many photos. And wish you all good remainder of the day and safe travels back to your destinations.
I guess that it is the hardest part for Biljan and me to do the closing and to say something very clever and nice and encouraging, but at the same time very short at the end of every year. But I'm really happy this year. I mean, I was listening discussions. I mean, I think that, and I still believe that on European continent and globally, European Convention and what European Court is doing and judgments are something really unique and extraordinary, giving us a lot of answers, not opening more questions, but giving us a lot of answers and binding answers. And that's very useful for us in the Western Balkans, because we believe that times of emergency are permanent here, that we are living in times of emergency all the time. So it's very important that we have something that is quite clear and that is giving us a lot of answers. And during the pandemic and after pandemic now, I saw how alive is the convention. When I was listening discussions, I mean, actually a convention that is quite old is still extremely useful. You know, the judgments are really something that are covering, can cover everything. So I'm really happy that we have excellent guests, excellent participants every year. Judges are here with us every year, and I'm really grateful for this, and hope that, as Biljana mentioned, next year we will make something better and bigger. It is really hard, but we will do our best. I guess probably in Sarajevo, probably in Sarajevo next year. This is the circle. And again, big thank you to staff of Earth Center, of civil rights defenders, interpreters, and everyone, and all of you that were with us during these 2 days, that contributed and do your best. So I hope that everything will be useful, and this is our small contribution, but I hope that it will be good for your everyday work. Thank you again.